Welcome to literary and jury charge practice. Let's start out with some literary. This is called When a Crash is No Accident. Ready? Here we go. A trucker was traveling south on Interstate 405 in November 2015 when he encountered the bane of all Southern Californians, slow traffic. It was nothing unusual for a Wednesday leading up to rush hour until the Toyota Camry in front of the truck suddenly hit its brakes. The truck driver attempted to veer and instead crashed into the car before tipping over. But something was fishy. The evidence in all of the interviews indicated there was no reason for the Camry to have slammed on its brakes, says California Insurance Commissioner Dave Jones, describing what investigators later discovered was a staged accident designed to defraud the truck driver's insurance company. Two of the Camry's occupants subsequently admitted that they were part of a conspiracy. The tool job, as that crash came to be known because the truck was carrying tools, is one of hundreds of auto fraud cases the state investigates each year. The California Department of Insurance, CDI, employs approximately 300 detectives to investigate several types of fraud, and about a third of its resources is focused on auto insurance scams. Since 2001, the CDI's Urban Auto Fraud Task Force has teamed up with California Highway Patrol, first responders, and county-level district attorneys to catch and prosecute organized criminals making false insurance claims. In many states, including California, insurance companies are required to refer suspected fraud to the CDI. The Auto Club of Southern California, for example, maintains a special investigative unit that looks into suspect claims using a variety of forensic tools to detect fraudulent activity. We have many success stories where we've confronted perpetrators about the scheme and they walk away from their claim because they were caught, says Jim Will, Vice President of Insurance Claims for the Auto Club. We also refer cases to local district attorneys for further investigation and prosecution when the evidence warrants it. Auto insurance fraud is a felony and the penalty could carry a significant fine, including jail time. CDI Detective Sergeant Jose Soloro was a supervisor with the task force that helped solve the tool job case. A 9-year CDI veteran, he is based in a nondescript office in South Los Angeles. We deal with creepy stuff, says Soloro, who has been called in on cases when CHP suspects foul play. When we make search warrant entries, we're finding a lot of illegal weapons. Auto fraud investigation is dangerous work because of so much of the high value fraud involves staged crashes that often are perpetrated by known gang members. Through the task force, the state has arrested members of the local Bloods and Crips and the MS-13 Mexican Mafia. Still, anyone can commit fraud. The CDI has also collared grandmothers and Major League Baseball players, whether perpetrated by those acting alone or by organized criminals. Auto insurance fraud takes many forms, from exaggerated injuries and crash damage to fake thefts and backdated claims. Although individual auto insurance fraud is more common, the losses to insurance companies are far greater on a per-claim basis in fraud cases involving organized crime and its favorite tactic, staged accidents like the tool job. The so-called swoop and squat involves as many as 3 criminal vehicles targeting a single unsuspecting victim, often a distracted driver in a high-value or well-insured car or truck. 2 of the criminal vehicles box in the victim on both sides, preventing the driver from switching lanes when a car suddenly pulls directly in front of him and slams on its brakes, causing a crash. As Soloro navigates a busy Los Angeles freeway, he scans the surrounding traffic with the mindset of the many criminals he's helped catch. He's looking at where people are driving, what they're driving, and how. You'll see people eating, fiddling with their music or phone, putting on makeup, he says. Fraudsters like to target distracted drivers because they often don't notice if other cars start to box them in. Soloro says a lot of swoop and squat squat crashes involve box trucks on highways with heavy truck traffic. As he passes a UPS truck, he notes that's a good target vehicle. Why? They have good insurance, so they've got deep pockets. Farther along the freeway, he points out a Mercedes. I also like this one. It's an expensive vehicle. The abundance of truck traffic and high-value vehicles are part of the reason auto insurance fraud is so prevalent in Southern California. Los Angeles, Riverside, San Bernardino, and San Diego counties accounted for about 60% of CDI prosecutions for organized auto fraud in the 2015-2016 fiscal year, totaling losses of $13.5 million. About 10% of the nation's insurance industry payouts are related to fraud, according to the Insurance Information Institute, and those losses are passed on to consumers in the form of higher premiums. Even if you're not personally a victim, you will be affected, Will says. Every consumer pays more for insurance because of fraud. Okay, let's try some jury charge practice. Ready? Here we go. A preponderance of the evidence means such evidence as, when considered and compared with that opposed to it, has more convincing force and produces in your minds a belief that what is sought to be proved is more likely true than not true. In other words, to establish a claim by a preponderance of the evidence merely means to prove that the claim is more likely so than not so. In determining whether any fact in issue has been proved by a preponderance of the evidence, the jury may consider the testimony of all the witnesses, regardless of who may have called them, and all the exhibits received in evidence, regardless of who may have produced them. If the proof should fail to establish any essential element of plaintiff's claim by a preponderance of the evidence, the jury should find for the defendants as to that claim. Although there are several defendants in this action, it does not follow from the fact alone that if one is liable, all are liable. Each defendant is entitled to a fair consideration of the respective case against him or her and his or her defenses, and is not to be prejudiced by your considerations or findings concerning the others. In order to recover damages for infringement of a trademark, the plaintiff has the burden of proving by a preponderance of the evidence that the defendant had either actual or constructive notice that the trademark was registered and therefore protected by federal law. The plaintiff may sustain its burden by showing either 1, that the defendant knew the trademark was registered, or 2, that the plaintiff displayed with its trademark the words registered in the U.S. Patent and Trademark Office, or a proper abbreviation thereof, or simply the letter R enclosed in a circle. A trademark is a word or symbol, or a combination of words or symbols used to identify a product, to distinguish the product from those manufactured or sold by competitors, and to indicate the source of the product. The owner of a trademark has the legal right to prevent its use by others without its permission. The unauthorized use of a trademark is called infringement of the trademark if the use of the mark in commerce creates a likelihood of confusion, mistake, or deception as to the source, affliction, or sponsorship of the goods. At all times relevant to this case, the plaintiff was the owner and holder of registered trademarks on the name Louis Vuitton and on various symbols used on products manufactured or distributed by the plaintiff. A counterfeit trademark is one that is not genuine or an unauthorized copy of a trademark. The distribution, sale, or offer for sale of merchandise bearing a counterfeit trademark constitutes infringement because the likelihood of confusion is clear and may be presumed. Plaintiff's claim in this case is for what the law calls contributory infringement. In other words, plaintiff does not allege that the defendants or any of them directly sold or offered for sale counterfeit Louis Vuitton merchandise. However, the plaintiff does claim that through their actions or interactions, the defendants contributed to the trademark infringement activity that was occurring in the flea market over a period of time. In order to establish its claim for contributory trademark infringement, the plaintiff has the burden of proving each of the following by a preponderance of the evidence. First, that one or more of the tenants of the Eisenhower Road Flea Market were selling or offering for sale merchandise bearing counterfeit Louis Vuitton trademarks. Second, that the defendants knew or had reason to know that the infringing activity was taking place in the flea market. And third, the defendants possessed the power and authority to exercise control over the tenants who were selling counterfeit merchandise. In order to establish the element of knowledge, the plaintiff has the burden of proving by a preponderance of the evidence that either defendant Bruce Gore or defendant Patricia Walker or both, one, possessed actual knowledge that tenants of Eisenhower Road Flea Market were selling or offering for sale counterfeit Louis Vuitton merchandise, or two, had reason to know of such sale or offer to sell, or three, were legally blind to such sale or offer to sell. Actual knowledge means the defendant or defendants possess specific knowledge that one or more tenants were selling counterfeit Louis Vuitton goods. Reason to know means that a reasonably prudent landlord or its agents would or should have known of the sale or counterfeit goods by their tenants. Willful blindness means that the landlord or its agents had reason to suspect that counterfeit goods were being offered or sold but deliberately failed to investigate. The element of control may be satisfied by proof by a preponderance of the evidence that Eisenhower Road Flea Market possessed the authority to evict a tenant, to terminate his lease, or to decline to renew his lease, or to restrict through provisions in the lease agreements by promulgating rules and regulations or otherwise the activities in which tenants were permitted to engage. Remember, the issue for you to determine is whether the Eisenhower Road Flea Market possessed such power and authority, not whether it chose to exercise it in a particular case. If you find from a preponderance of the evidence that any defendant is liable to the plaintiff for contributory trademark infringement, you should consider the issue of damages. In arriving at an amount of damages to be awarded to the plaintiff, you should first determine which Louis Vuitton trademarks, if any, appeared on merchandise sold or offered for sale by the tenants at the Eisenhower Road Flea Market. After you have done so, you should determine the number of different categories of merchandise upon which that counterfeit trademark appeared. By statute, you may award not less than $1,000 nor more than $200,000 in damages per counterfeit mark per type of goods sold or offered for sale. If, however, you find that any defendant's conduct was willful, you may award not more than $2 million per counterfeit mark per type of goods sold or offered for sale. As used in these instructions, the word willful means that the person acted with actual knowledge that his or her conduct constituted an infringement, or that he or she was reckless in not knowing that fact. In awarding statutory damages, you are not required to find that the defendant's actions caused a specific financial harm to Louis Vuitton, nor that Louis Vuitton is able to quantify the harm, if any, which it sustained. The purpose of awarding statutory damages for trademark infringement is to deter the defendants and other contributory infringers, actual and potential, from engaging in similar conduct. In arriving at the amount of damages, if any, you choose to award, you may consider a number of factors, including but not limited to the following: 1. The degree of willfulness on the part of the defendants. 2. The defendant's cooperation in providing information about infringing activity. 3. The profits, if any, realized by the defendants as a result of the infringing activity. 4. The value of the trademarks which were infringed. 5. The revenues, if any, lost by Louis Vuitton as a proximate result of the defendant's conduct. 6. The need to deter the defendants and other landlords similarly situated from engaging in contributory trademark infringement. Of course, the fact that I have given you instructions concerning the issue of plaintiff's damages should not be interpreted in any way as an indication that I believe the plaintiff should or should not prevail in this case. Your verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. In other words, your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement, if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but only after impartial consideration of all the evidence in the case with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinions if convinced it is erroneous, but do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. Remember, at all times, you are not partisans, you are judges of the facts. Your sole interest is to seek the truth from the evidence in the case. Upon retiring to the jury room, you should first select one of your number to act as your foreman or forewoman, who will preside over your deliberations and will be your spokesperson here in court. A form of verdict has been prepared for your convenience. You will take the verdict form to the jury room, and when you have reached unanimous agreement as to your verdict, you will have your foreman fill it in, date and sign it, and then return to the courtroom. If during your deliberations you should desire to communicate with the court, please reduce your message or question to writing signed by the foreman or forewoman and pass the note to the marshal, who will bring it to my attention. I will then respond as promptly as possible, either in writing or by having you returned to the courtroom so that I can address you orally. I caution you, however, with regard to any message or question you might send, that you should never state or specify your numerical division at the end. See what we have for some more literary practice. This is called The Long and Short of Car Loans. Ready? Here we go. Would it be a bad idea to take a long car loan so that I can afford the payments on a new pickup truck? If you sign up for a long loan on your dream truck, you'll have plenty of company. In the first quarter of 2017, about 39% of buyers who financed their new vehicles took out loans lasting between 5 and 6 years, and another 35% took out 7-year loans, according to Experian Automotive. By contrast, in 2010, 7-year loans accounted for 17% of new vehicle loans. Long loans are becoming common in the used car market too, with more than 40% of those who borrowed money on 2014 and never used vehicles taking out 5 to 6 year loans. That means a vehicle could be nearly a decade old by the time the loan is paid off. The high price tags of new vehicles are fueling the trend. According to Forbes.com, the prices of the 3 best-selling pickups, the Ford F-150, Chevy Silverado 1500, and Ram 1500, have jumped 23 to 26% during the past 20 years after adjusting for inflation. But it's not simply a matter of automakers sticking it to buyers. Buyers demand all the latest doodads, from 360 view surround cameras to Apple CarPlay. Technology costs more, says Melinda Zabritsky, a senior director at Experian. The average new car now goes out of the showroom for more than $30,000, and that's not even for an especially fancy vehicle. So are long loans foolish? Maybe not. Today's cars are more reliable and last longer than when the typical car loan ran for only 2 or 3 years. And car warranties are much longer even for used cars. Powertrain warranties can be for as many as 10 years or 100,000 miles. Ditto for some certified pre-owned vehicle warranties, which means car owners don't have to worry as much about costly repairs while they make those pesky monthly payments. Perhaps as a consequence, motorists are keeping their vehicles longer. In late 2016, IHS Markit found that the average age of cars and light trucks on the road is nearly 12 years, and that motorists typically hold on to their vehicles for 6 to 7 years. That said, the longer the loan, the more your truck will cost you in finance charges, and you'll pay more total interest on a 5-year loan than on a 4-year loan, even at the same rate. Longer loans also tend to have higher interest rates. Moreover, the longer the loan, the longer you'll likely be upside down, that is, owing more on your vehicle than it's worth, which means you'll have to pay the difference between its trade-in value and the loan balance if you want to buy another vehicle before you get right side up. This is a particular problem. Currently, 3 million vehicles came off lease in 2016, followed by another 3.5 million vehicles in 2017, driving down used car prices. Things to think about: suppose you need a cheaper vehicle because you lost your job or are going through a divorce. Or what if gasoline prices spike and you can't afford to drive a gas-guzzling pickup? Or you become sick and can't drive, or sick of the pickup because it's in the shop all the time. Or you just want a vehicle with the latest technology. Consider the 24-10 rule. Make a down payment of at least 20%, keep the loan term to 4 years or less, and keep the cost of the monthly payments and insurance to 10% or less of gross household income. If you can't stay within these guidelines, it's probably wise to purchase a less expensive vehicle. But if instead you go for a longer loan on your dream truck, as Zabritsky warns, you'd better be sure you'll love and keep it, maybe not until death do you part, but for a very long time. All right, and we will stop there. That will conclude our literary and jury charge practice.